All right.
Okay, welcome to the Local Revenue Subcommittee for Ways and Means. I'm Delegate Kent Roberson, your chair, and we are starting with House Bill 1110. Mr. Ward, if you could read synopsis of the bill or share synopsis.
Sure. So this bill just changes the process for in-rem foreclosure on vacant and abandoned properties. So that's a process that counties and municipalities are already authorized to use, but only Baltimore City has enacted it so far. And it basically, the change that the bill makes is it just eliminates a statutory requirement for notice to interested parties in a foreclosure within 5 days after filing of a complaint and just relies on the Maryland rules, which provides for the same requirement. And the idea is just to follow the Maryland rules in case the rules change at some point, that we don't end up with a redundant requirement in statute.
Thank you. Is there a motion on the bill?
In favor.
Is there a second?
Yes, yes, yes.
We have a second.
I can second.
Thank you, Delegate Williams. Any discussion? Delegate Hartman?
Thank you, Mr. Chair. So, for council, so as far as removing the requirement, what's the problem with the notice? Why are we doing this? What are we fixing?
So you're just basically this requirement for notice within 5 days after filing the complaint already exists in the Maryland rules, so there's no need for it to be in statute. And if at some point the Maryland rules were altered to require a different time frame or something like that, you would end up with a redundant requirement. So we're just following the Maryland rules, which are what normally applies in this kind of circumstance. So just removing basically a redundant statutory requirement.
Okay, thanks.
Thank you, Mr. Ward. Any other questions? All right, all those in favor of moving House Bill 1110? Raise your hand, say aye.
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 That's 4. And then any opposed? Oh, you aye, Delegate Hartman?
I'm good.
In favor? Okay. 5 in favor. House Bill 1110 is moved favorable to full committee. Next, we're looking at House Bill 1148. Mr. Ward, if you could share what the bill does, and then also there is an amendment on the bill as well, if you could share that as well.
Sure. So this bill does several things. So first, it allows heirs to access payment plans through the state tax sale ombudsman. It sets up the what's called in the bill the Heirs Protection Program, which includes outreach to households where the owner has died. It includes providing information on how to probate an estate on the state tax sale ombudsman's website. There would also be free legal services provided with grants to legal services organizations to help heirs get their properties titled in their name. It also provides grants directly to heirs to cover required taxes and fees, to probate an estate, and to get the dwelling titled in the heir's name. It also sets up a fund to pay for the program. So the fund is funded by $250,000 of state property tax revenue and then $500,000 contributed by counties. And that's from all the counties collectively. So the total funding is $750,000 for the program. It also expands eligibility for the homeowners and homestead tax credits to include heirs. So heirs could qualify for those credits for up to 3 years. And the purpose of that is to allow them to have access to those credits while they're going through the probate process and getting their dwellings titled in their name. And that's the bill. And then the amendments make several changes. So the first is to change the name of the program to the Legacy Protection Program rather than the Heirs Protection Program. And that's just to avoid confusion with the existing Homeowner Protection Program, which has the same acronym, HPP. So this would now be the LPP. It changes the effective date for the Legacy Protection Program to July 1st of 2027. And then it also makes a couple of other changes. So under the bill as introduced, the value of a home that would be eligible to participate in the program is $350,000. The amendment raises that to $450,000. to make that consistent with what you did in House Bill 753 when you raised the eligible value of a home up to 450,000 for the homeowner protection program. And then the other change that made in the amendments is that it allows for any tax or fee that's required to complete probate and get the home titled in the heir's name to be paid through grants from the ombudsman. So the ombudsman would retain discretion as to which fees to cover and how much to pay on a case-by-case basis. But this would make basically any required fee or tax eligible for payment, and those grants are targeted towards low-income homeowners. And those are the amendments.
Thank you, Mr. Ward. I'll take questions, I guess, first. Delegate Long, since he's.
Yes, since this has been changed and raised, one of the questions I have, is there a means test as far as what's the cap on income? I mean, how is that going to be addressed?
Right.
Is there a means test?
Right. So the bill does not have an income cap. There's no income cap. It's a cap on the value of the home, which is currently 350,000. In the amendments, it would be 450,000. There is, for the grants specifically, the ombudsman would have discretion to establish an income cap, but that would be at the discretion of the ombudsman.
Right. Well, I thought that's what this bill was all about, to help people that couldn't afford to take possession of a property that they were heir to. So I'm just a little confused why there's not a cap as far as, means tests, something of that. But so it'd be up to the ombudsman.
Right. For purposes of the grants to cover taxes and fees, that would be the ombudsman's discretion whether to adopt an income cap. There is a
Okay.
cap on the value of the house.
Right.
Mhm.
Thank you, Doug. Thank you, Mr. Ward. Thank you, Delegate Long. Delegate Hartman?
Thank you, Mr. Chair. So is it safe to say we're assuming that if somebody's inheriting a house of $450,000 or less, that the heirs to that house would be in need of this 3-year extension of any tax credits or whatever that have existed regardless of the wealth of the person receiving the property?
So for the homestead, that credit is already available to any homeowner regardless of income.
But
And
we're
then-
extending that to the heir, though, correct, with this bill?
That's right.
For
Yes.
3 years, unknowing, they're not necessarily a homestead person.
Okay, so actually they are required to be resident. It has to be their primary residence. They have to meet all the requirements for the homestead that are currently in law. It just is, the only difference is that they wouldn't have to be the record title holder. They don't have to have their name on a deed that's recorded in the county clerk's office. So that's what this change is. So it basically gives them a 3-year period to go through probate and get the home titled in their name. So for the homestead credit, so they're accessing these credits on the same terms as everyone else. The only difference is that this gives them a grace period to get the home titled in their name. And then for the homeowners, they have to meet income requirements for that, just like any other applicant would have to, because that's
So
a
then
means-tested
this is
program.
only applicable for somebody else living in the house. If I'm living in my aunt's house and she passed away, leaves it to me, this is only applicable for somebody that's currently living in the house at the time the person on record on the title has passed away.
Exactly. Yes,
Okay.
it has to be their primary residence.
Gotcha. Thank you.
Mhm.
I have a real quick question for Stan, if you wouldn't mind, just for clarification. Wouldn't the deceased person that was titled in the property or the owner would be getting a homestead property tax credit? Wouldn't they still be eligible for that because the title the deed has not changed names? So does that have anything to do with? I'm just for my own information.
Yeah, thank you for the question. Yeah, we looked into that. And in fact, when a homeowner dies that's getting the homestead or homeowner's tax credit, SDAT cancels the credit.
Okay, well, I'm good with it then. That's fine.
Okay, good. So is there a motion on the amendments? You're on mute, Delegate Williams. Is
So move.
there a second?
Second.
Thank you. All in favor of the amendments as presented, signify by saying aye, raise your hand.
Aye.
See. Self, Delegate Williams, Delegate Long, I think your hand is raised, it's out of view. Delegate Young, Delegate Hartman. Delegate Hartman stepped away, so 4 in favor, and none opposed. All right, is there a motion on the bill as amended?
So move.
Second.
Thank you. It's probably moved in second. Any other discussion? Hearing none, all in favor of the bill as amended, signify by saying aye, raising your hand.
Aye.
See myself, Delegate Williams, Delegate Young, Delegate Long. Yes, Delegate Hartman, are you on HB 1148 as amended? Just raise your hand if you're in favor, or if you're in favor. Okay, perfect. All right, so we have 5 in favor. The bill moves favorable to the committee. I'm going to hold because there's some conversation need to be had on HB 734, and then just so you know, we'll probably be meeting on Tuesday before committee, but HB 734 and 1330. 734 and 1330 will be probably discussed during that, along with some others. So look forward to those discussions. This committee is adjourned as of 12:31.
Thank you.
Thank you all.